Good afternoon. So this one's an audio because I have some sort of cold thing going on and I look like death warmed up. So anyway, you know what it's time for you to do? It's time to boil the kettle, make a green tea or a chai or an English breakfast tea. I always go with I like Yorkshire tea, and I quite like Twining's Russian Caravan. That's pretty good. Anyway, so grab your drink of choice and a snack too. Bring a snack, and let's dive in to some of the misconceptions, oversimplifications about law, consent, and government systems. And there's some really awake, awesome men and women who, especially since, all the things, can you believe, since 2020, half a decade has gone by, there are some amazing humans, men and women. And please, someone gave me the definition of what they thought the etymology of the word human is. I'm not going down that rabbit hole today. But let's have a look at what this truther movement, this kind of just awake men and women, what rabbit holes they're diving into. However, I see a lot of paint being thrown at the wall. Lots of colourful balls of paint thrown at the wall, and we're just hoping that we create a colourful collage, or we're just throwing something at the wall hoping that something sticks, but that's just not really how real life works. So quite a lot of these concepts I've been compiling over the past few months, and I just thought, you know what, let's just bring them to the table and see what sticks and what doesn't. The first one, you didn't sign a law, you signed a form, and that's not law, that's consent. Now, I think the flaw in that is that it falsely equates signing a form, like for a driving license or tax file number, with creating a contract that replaces statutory law. Forms enable participation in statutory schemes. They don't override law. I kind of feel with those two examples, consent here isn't the same as contractual consent under private contractual law. It's regulated participation in a public administrative process. By the way, just another disclaimer, I always have to give these disclaimers. I'm just speaking ideas and concepts out loud. This is to bring topics to the table, and I want everyone to contribute in the comments about each point. Let's pick them apart and see what works and what doesn't. The next concept that I heard not long ago, everything the system does to you, it does because you said yes without even knowing that you did. Okay. So when I was born, I didn't get to choose some things, right? But the flaw in that is this leans on the idea of tacit consent. But government action is not solely based on consent. It derives from statutory authority and delegated legislation. You don't need to agree to taxes or Centrelink rules for them to apply. They're backed by legislation passed by Parliament. Tacit consent in contract law doesn't apply the same way to public law. There's a different legal framework at play. I'd really find it interesting from some mentors that I really respect in this space to really add to that and explain the ins and outs of that, please. Okay, the next concept. There's a big difference between law and administrative policy. 100% accurate, yes. Laws are passed through legislative processes, while administrative policies are the internal guidelines by which government departments operate. But I do see a flaw in that, policies and codes are arbitrary and unenforceable, not true. So when policies are made under valid legislative delegation, they do have legal effect. For example, in Australia, Centrelink rules under the Social Security Act. Now, so let's look at things like tax file number, Medicare, Centrelink, PAYG, pay as you go, and the driving license. Now, these are statutory schemes. While voluntary in participation, for example, no one is forcing your hand to apply for Centrelink. Once you opt in, the rules are not optional. You can't really have your cake and eat it too, folks. The rules are set out in legislation and carry enforceable obligations. Not applying for a license doesn't give you the right to drive. It means you can't lawfully drive within their system. Are you all keeping up with me? And thanks for putting up with my blocked nose voice. The next concept. You didn't read a law, you filled out an application, tacit consent. Now again, I see the flaw. The idea that applying for a license or a tax file number equates to a private commercial contract is incorrect. These are statutory instruments, not common law contracts. Consent under public law is not the same as consent under contract law. Something I heard last week, a man said, if you don't say no, they treat it as a yes. I see a flaw in that. This misrepresents how jurisdiction works. Refusing consent doesn't stop the law from applying. Jurisdiction is not lost because you didn't opt out. In fact, you can't opt out of a law that applies territorially or based on statutory obligations. For example, tax, if you are conducting your activity under their jurisdiction. Okay, here's another one. They've used the word people. Most people aren't governed by legislation. They're governed by contracts disguised as government. These are just my humble thoughts, right? So I am up for someone correcting me on this or being a devil's advocate. Let's just bring this to the table, right? I feel it's factually incorrect, and I'm very black and white, okay? Tax law, social services, vehicle registration, these are created by acts of parliament. So if you're doing those activities under their system, under their jurisdiction, right? Pay attention to what I just said. Look, there may be internal procedural agreements, for example, Centrelink's mutual obligation agreement, but they derive from law, not replace it. A lovely lady who I have all the time for said something to me that just isn't sitting with me yet, so I'd love to hear what your thoughts are. Consent can be withdrawn and you return to your natural standing. Now, there's some really great groups out there all trying this stuff, right? The flaw in that could be there is no lawful process recognised by Australian courts that allow you to withdraw consent and exempt yourself from statutory obligations like tax, licensing or Centrelink rules, for example. Now, look, you can exit a specific scheme. For example, stop receiving Centrelink. But that's not the same as stepping outside the law altogether. Does natural standing have any legal recognition in Australia or any other common law jurisdiction? maybe we need to use the system against the system and use some sort of commercial process for that, but that's for another day, hey? What if we said, we've tested the process. When you understand consent, you stop asking for permission. All right, well, the first thing there is, and you can ask my daughters, I'm always pulling them up on the word understand. I prefer the word comprehension. Some say inner stand. I don't want to stand anywhere, right? I want to comprehend. Anyway, I believe that this statement, it implies that there's a working lawful process for opting out of statutory obligations. But so far, unless I want someone to bring this to the table and prove me wrong, no such process has stood up in court. So is that a flaw? Look, many who follow these ideas find that the courts just steamroll. They ignore such arguments and in some cases impose actual greater penalties. They punish, right? I would love to hear from anyone who's gone through the process. That would be super awesome. So really, some of these statements, ideas that I've heard in the truth of movement recently, I feel that, let's look at it in summary. Number one, they misapply contract law to statutory governance. Number two, I believe what they're saying misrepresents consent, as if participation equals a private commercial contract. Number three, they ignore statutory authority. Parliament-made law is not based on individual agreement. Number four, a lot of this stuff just has no legal recognition. And I joke all the time, we can't move to Privacy Planet. There's no shuttles going there this week. So do they even have any lawful effect in practice? And number five, and this is the big one for me, there's a lot of dangerous oversimplification, which I feel could mislead men and women into ignoring legitimate obligations with serious consequences if they are operating in those jurisdictions. For example, tax evasion, driving unlicensed, right? Please add to the conversation about those topics. I really would appreciate it. So, okay, for the past, 12, 13 minutes, I sound like a bit of a negative Nancy, don't I? A bit of a naysayer. Something I do say often is let's focus on what we can do, not what we can't. So what can be done for remedy based on real world conditions instead of looking at the reckless 2% of kind of truth or picking sentences out of magistrates' monologues that suit a narrative, all right? I believe we need to be grounded and we need to address these issues transparently without misleading elements, okay? And I feel that the statements I've just shared that I've heard over the past half a decade, they're like slivers of truth, right? The idea that many government systems operate with assumed consent and stretches it into a misleading narrative that can cause real harm, which I have seen, right? Now, look, don't get me wrong. Yes, some systems rely on voluntary participation, right? For example, applying for Centrelink or a tax file number. That's voluntary. No one's putting a gun to your head to force you to fill out the tax file number application form, right? And yes, it's true that many enter into agreements without fully comprehending the legal implications. On the daily, you tick a T's and C's box to buy a pair of sneakers. Did you actually read the T's and C's? I don't think so. But to suggest that all statutory obligations vanish once you withdraw consent is legally and practically false. To act on that belief without knowing the full scope is reckless. It is like taking 2% of truth, bending it to fit a feel-good message and selling the illusion of immunity from a system that is, in reality, complex, layered, and legally enforceable if we're conducting our business, if we're conducting our actions inside of that system. Right? So let's look at real-world remedy options based on lawful reality. So look, if you're serious about reducing exposure to administrative overreach, but also standing on a lawful footing, let's look at some stuff that we can actually do. And I'm just putting these ideas out there, okay? I'm not saying to do them. I'm not saying not to do them. I want us all to weigh in on the conversation, please. So, number one, we could withdraw from specific schemes legally. You know what? Make a decision. Take a high level of responsibility. It may not work for everyone, right? Stop receiving Centrelink. Deregister an ABN. Structure your affairs to legally reduce tax exposure. But these must be done within the rules, not by denying the system exists. It's not like we can't be a toddler and put our hands over our eyes and think that no one can see us, okay? Number two, we can look at using lawful structures to regain autonomy. Example, set up a private membership association to operate privately while respecting the law. Do no harm, cause no loss, and it is very important that our umbrella structure has the correct international laws, covenants and treaties. That's very important. When it comes to assets, property, look at lawful trusts for asset protection or estate planning. You could shift business activities to a private contractual model where suitable, especially in things like wellness, education spaces when you're being of service. Absolutely. Now, are you up for the fight? Because number three, challenge unjust actions through proper channels. You can challenge administrative overreach via, yes, these channels though, are these channels set up to fail? But I'm just going to say the channels anyway, right? Judicial review, freedom of information requests, lawful notices. But making unfounded assertions about contracts you never agreed to will probably get you ignored, and that will escalate and get you fined or worse, right? And I will use that word again, escalate. I really believe our power comes in educating ourselves, taking a higher level of responsibility. Educate, don't escalate. I think we need to learn to navigate the legislation. We need to comprehend international covenants and private agreements, not to escape obligations, but to reposition yourself intelligently and lawfully. Another guy I heard last week, what did he say? He said something like this. Simply declaring yourself free, right? That's what he was talking about. And my thought was, well, if you're told that simply declaring yourself free or refusing to comply with will make statutory obligations disappear, you are being sold a fantasy. Look, it's very seductive. My voice is not very seductive today, though, is it? It sounds terrible. But it's not lawful and it's not enforceable. I believe real remedy comes from comprehension, not rebellion. And the moment you comprehend the system, you stop being manipulated by partial truths and start playing the game lawfully with clarity and precision. I really believe that sharing misinterpreted information, like the points that I listed above, is dangerous for several serious reasons, both legally and personally. Here's why. Number one, they of course can have legal consequences for yourself and others. I believe those who follow this sort of advice like refusing to pay tax, drive without a license, or ignore fines based on the belief that it's all contracts, 9 times out of 10, I've seen it. They're hit with heavier penalties, interest, or criminal charges, right? They could lose their property, income, or access to services due to enforcement actions. They could face court orders, default judgments, or even jail time. This is the danger. Those who act on this misinformation, thinking they're free or becoming untethered, may be blindsided when the system responds with lawful enforcement, and by then, their goose is cooked, the horse has already bolted. It's often too late to repair the damage easily, and I can say that firsthand. Many amazing living men and women come to the community I'm in after the horse has bolted. We would much rather be there for you with real remedy that works on a practical, operational, logistical basis on this planet, that's set up, that covers both your ass cheeks, right? The public and the private jurisdictions, and to make sure that these structures and processes are watertight, that all the holes of the ship have been bunged up, right? Risk mitigation, protection. And I think that comes from educating ourselves. That is the first step. So I love having yarns about this sort of stuff. If anyone wants to just reach out to me, you can DM me on Instagram. You can, put a comment in here, reach out, and there's just a plethora of amazing resources, tools, education that I can direct you to. So anytime, all right? Now, I believe a lot of the statements that I said earlier in my chat with my croaky voice, I believe it gives a false sense of empowerment, right? These narratives often make people feel, I'm able to opt out. Oh, they have no authority. I'm protected. But in reality, these beliefs don't hold up in court, and that false sense of power can lead men and women to ignore deadlines, legal notices, and court appearances, digging themselves deeper into harm. Also, a lot of the educators in this space who are selling those types of dreams are not living it in the real world behind closed doors. Again, I've seen that firsthand. If you want to chat with me about that, door is always open. And I believe that just by recklessly taking 2% of information, it can harm vulnerable or desperate people. Again, the ones that are selling these high-ticket items, look at their intention, right? Maybe they're doing it for the betterment of the world and mankind. Or maybe they're doing it to, buy bottles of champagne and Camilla robes. I don't know, right? I can't make assumptions there. But I find that they seem to hone in on the vulnerable, right? Men and women in debt, men and women with court battles, family court, financial hardship are often drawn to these ideas because they offer hope, and there's nothing wrong with hope, right? But the solutions aren't usually tested by the ones selling it. Now, in saying that, there are some really great mentors and educators in this space that I, again, have seen firsthand are walking their talk. Again, feel into their energy. Look at their eyes when they're talking, okay? To be honest, a lot of these schemes, when they fail, the emotional and financial fallout can be worse than before. Many who follow these ideas have lost homes, custody, or had their situations made far worse because they stopped engaging with the system in a lawful, strategic way. And why haven't they reported the cowboys that they purchased from? Because they're too scared. They've been backed into a corner and they're scared to admit that, right? So I also feel that these reckless points that I've just mentioned, it actually undermines the legitimate lawful education in a community of men and women who are really sharing amazing stuff that has legs, that really does work on planet Earth, right? There are real lawful ways to reduce control, protect your assets, and stand in your sovereign capacity. Again, if you want to know the difference between sovereign and sovereign, hit me up. I'll send you the link. And there's lots of ways we can do that through unincorporated associations backed by international law, trusts, Uniform Commercial Code filings, as long as it's done properly, lawful notices and more. But when false ideas flood this space, right, this is what happens. Courts lump all lawful remedy efforts into a conspiracy theory or sovereign citizen bin. It also becomes harder for serious lawful educators to gain traction or credibility, right? The huge danger is misinformation undermines the real path, making it harder for everyone else to walk lawfully, confidently, and effectively. And the thing is, a lot of these cookie cutter, templated, piecemeal approaches, right? It can be used against you and others later. I believe he who makes claim bears burden of proof. Statements made publicly online in letters in court can be used as evidence, right? So if you did a written statement of claim and you listed your turnover, right? You listed your turnover, say January 2023, and you said it was $80,000. Then you listed your turnover for January 24 and you said it was only $20,000, but you said you ran a not-for-profit organisation. Well, you've just put that evidence into the public system under the watchful eye of, for example, the ATO and ASIC, right? You've literally reported yourself. You know, these things can be used as evidence against you, to claim you're rejecting the rule of law, to link you to anti-government movements. That's not seen as positive in their eyes, right? To justify stronger enforcement or surveillance. You know, in some countries, courts have denied remedies or protections because people relied on, state national arguments that had already been debunked, right? Case precedents had already happened. I'm not talking about Australia, I'm just saying in general, okay? So, again, I need to take another sip of my tea, and I've got a lot of Manuka honey in this tea. Why is it dangerous? I believe sharing misinformation type of content or selling automated courses with templates, right, without correcting it or qualifying it is dangerous because it encourages people to make decisions that have real legal consequences. It distorts comprehension of how law actually works. It sets good men and women, Harkin's barking, saying yes, he agrees. It sets good men and women up for failure, fines, court orders, or worse. And most importantly, it discredits legitimate remedy paths, and there are some that do actually work when based in lawful reality. So, Harkin wants to know who's walking past our house, so I'm going to go. If you want to chat more about this, happy to have a yarn and put comments in. Let's all contribute. I'm going to see what Harkin's barking at and be well.